Hello, my voice is audible.
Yes, Mr. Sumit, you're audible.
Ashish sir, my voice is audible to you.
Yes, Sumit sir, you are audible to everyone. Kindly start the session. Yeah.
Ashish sir,
Yes, you are audible. Sumit sir, you are audible. Very much audible.
okay. This is the patent age of new inventions for killing bodies and for saving souls. A very good morning to everyone. I, Sumit Kishore, Assistant Professor, Department of Mining Engineering, Jharkhand Rai University, take honor to extend warm welcome to all the participants on the third day of E-Faculty Development Program on Intellectual Property Rights and its application. A patent is a type of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of time. The today's session will be on the topic patentability procedure with case studies. I am pleased to welcome Dr. Digvijay Singh sir, Assistant Professor, Department of Legal Studies, Central University, South Bihar, Gaya. He is a member of Internal Quality Assurance Cell of Central University, Gaya. He has a diverse knowledge in the field of intellectual property rights. Dr. Digvijay Singh has enriched his research activities with a good number of articles, research paper, conference proceedings in his domain. He has received doctoral fellowship from Indian Council of Social Science and Research, New Delhi. Welcome you, sir. Thank you
Thank
for
you,
your
sir.
gracious presence.
Thank you, sir. Thank you very much. Am I
Today,
audible to
in
all?
this session, he will throw light on patentability procedure with various case studies. I would like to request Dr. Digvijay Singh sir to address the conglomeration. Participants are requested to put any type of question they have queries or doubt in the chat box during the presentation. Uh, Now, sir, please proceed.
Okay, sir. Thank you very much, sir. Am I audible to you?
Yes, sir, you
Am
are
I
audible.
audible to
Yes,
you?
yes, sir, you are audible, sir. You are audible.
Okay, okay. So, sir, kindly allow me to share my PPT, then I will proceed. Yes. I hope the PPT is visible to all of you. Anybody just confirm? Okay. Okay, now a warm good morning to all of you. I'm Dr. Digvijay Singh, and today I will be interacting with you all over the theme that is procedure of patent procedure in India. But before that, a very warm good morning to all of you. I convey my wishes to Dr. Khalida Rahman, who is head of the Department of Legal Studies, Jharkhand Rai University, all the faculty members, registrar, vice chancellor of the university, and basically to Mr. Mithilesh Pandey, who approached me and asked me to deliver that lecture in this faculty development program. I'm very happy to be a resource person in this session, and this is my area of study or area of research. I'm doing this research in this IPR and teaching this IPR since last 6 years. So I will try to justify myself over the issue and let not you down over this particular issue of Indian patent procedure in India. If I start we all know that a patent is a form of IP protection, intellectual property protection. Patent is not only a form of IP, intellectual property, rather it is one of the most important form of intellectual property. Why? Because there's a huge chance of commercialization globally. Any patented invention will have the opportunity to be exploited globally, and that's why a patent protection over that invention is not only required in the domestic law, in the municipal law, rather at a global level. And that's why we usually refer in our discussions over patents law the Paris Convention for the Protection of Industrial Property, which was concluded in 1883. That document was the first multilateral document dealing with the standards of protection of industrial properties, including patents in the world. When we come to the introduction of patents, we all know that patent is a limited monopoly. Patent is a limited monopoly granted by the state to the inventor. This monopoly is granted by the state to the inventor, and that's why we use a particular term, that is grant of patent is based on Faustian Pact, a kind of agreement between inventor and the state, that inventor has to disclose his invention, then only state will grant patent protection. Disclosure is must. The grant of limited monopoly in favor of inventor is based on disclosure. And if any inventor doesn't want to disclose his invention to the people, he may have option to go for trade secret protection. If he wish to get protection of patents law, the primary requirement of the patent law is that there must be disclosure. Disclosure is must, and that's why we use a particular term, that is Faustian Pact. The patent protection will only be granted if you disclose your invention. And here arises a question, why disclosure is compulsory under patent law? A question may arise in your mind, why this disclosure is required? If I don't disclose my invention to the patent office, why I should not be granted patent? In that situation, the justification is that, the philosophy behind that disclosure is that your disclosure of your invention would be a raw material for further research in the domain. And that's why disclosure of as much as possible inventions are necessary for further growth of science and technology in a country. If every researches are secret, there will be no further researches. If every technology is secret, there will be no further improvement of development of technology. Yes, Mr. Raghuvanshi, you're audible. Is there any disturbance on my part?
No, sir. No, sir.
Okay, I continue. That limited monopoly will be granted after disclosure of your invention, and I try to justify that why disclosure is must. Disclosure is must to provide opportunity for further researches, further innovations, inventions, and all. When we ask for this limited monopoly, where disclosure is must, that disclosure gives an opportunity to the person skilled in the art to go for further researches. And in this way, under the name of limited monopoly, patent grants exclusive right to the patent holder, the inventor. Exclusive right is given to the patent holder in the name of grant of patent, and that exclusive right enables patent holder to commercially use that invention and generate revenue. Now again, there is a question, why that inventor is given opportunity in the name of limited monopoly to have this opportunity to generate revenue, because he has invested a huge amount of money and time in coming to the conclusion in inventing something, if he will not be incentivized, he will be given such kind of opportunity to generate economic revenue, then he will not further do any research, and there will be no any further improvement or invention on his part. And that's why, to incentivize inventions, commercial exploitation to the inventor is must. That is also one of the justification for grant of patent. When we proceed further, as my topic of discussion is the patent procedure. What is the procedure for the grant of patent in India? Under patents law, unlike copyright law, you all might be knowing that under copyright law, the registration is optional. The copyright protection is based on the idea of the no formality principle, that is, no formality is required in case of copyright. The protection of copyright will be available automatically, but it is not same in case of copyright. In patents. Under patents law, registration is must. Registration is must because the inventor will be given a monopoly. And if a monopoly is given to someone, there may be a huge chance of exploitation. And to have a check and balance of a monopoly, there will be a proper procedure of registration, and formalities will be checked. Then only patent shall be granted. The application has to be filed. It is mandatory. It is compulsory under patents law. In no jurisdiction in the world, patent is granted without formality of filing of application. Filing of application is must. And there are two principles. One is first to file and one is first to invent. If it is asked to you, who should be given patent protection? The person who first invents an invention or the person who first files application? Mr. A has invented something, and Mr. B files application for grant of patent over the invention of Mr. A in his own name. In that situation, controversy will arise in determining who is inventor, and to avoid such kind of situation, there is a global rule standard that the first file principle is accepted. That is, the person who first files application shall be granted patent. You might be a good inventor. You may have invented a breakthrough invention in the field of technology or in any field, but you don't approach to the patent office for grant of patent. You don't file an application. Definitely, you are not going to receive any grant of patent by the government, by the patent office. What is the requirement? The requirement is the filing of the application. You have to file. You must file application for grant of patent. If there is no filing of application, no grant of patent. The controversy arises if there are two scientists, and one is inventor and another scientist has filed application for grant of patent. And this is the question before court, High Court or Supreme Court, to determine who was the first inventor. Actually, all the researches, all the inventions are taking place at a secret place. And in that situation, it will always be a difficult task to determine who was the inventor. That is also a multi-billion-dollar question, a multi-billion-dollar litigation question before court to know who is inventor. To avoid the situation of controversy, the world community, all the nations have accepted a particular principle that is called as first to file principle. Means patents shall always be granted to that particular inventor who files application, who first files application. Actually, in the background, first to file and first to invent, these are the two principles. United States of America was following that principle, first to invent, and the rest of the world was following the principle, first to file. And in the meantime, United States of America tried to convince other countries to follow first to invent principle rather to follow first to file principle. but no country was agreed to the demand of United States, and ultimately keeping in mind the billion-dollar litigation issues in United States of America, United States of America in 2012 also agreed that first to file principle is better. But to satisfy its ego, the United States of America doesn't use the term first to file, rather, it uses the term the first inventor who files the application. And that is the discussion regarding filing and inventing. The filing is must. No doubt in India, there is no controversy that India follows first to file principle, and the filing of application is must, and the person who first files application is presumed to be inventor, and he is allowed to proceed further and granted patent in India. There is no controversy over this point. Now, come to the next part. My PPT is not moving. Can anybody help me?
Sir,
So
sir,
maybe,
please, sir,
yes,
yes,
sir.
sir, please press enter button.
Okay.
We'll move to next slide.
Slide is up, but it is not moving. It is not moving as my cursor is showing some kind of pen pencil like that.
Sir, can you use arrow button? Down button.
No,
down.
I'm not able.
Page
I'm
down.
not down button.
Yes,
Down
yes.
button से भी नहीं आ रहा सर.
तो इसको एक बार सर आप प्रेजेंटेशन मोड पे लाइए ना, स्लाइड शो मोड पे लाइए.
Okay, let me.
फंक्शन प्लस F5.
पेन पेंसिल टूल समथिंग एक्टिवेट हो गया इसलिए थोड़ा सा हो रहा है. Okay,
Sir, you minimize your PPT, then again you open it.
okay. Sorry for inconvenience. Okay. Now I hope the next slide is visible to all of you. Anybody just
Yes, sir,
confirm?
next page is visible.
Okay.
Yes,
Okay.
yes.
Okay. Sorry for inconvenience. Now, as we understand that the filing of patent application is must for grant of patent, now I proceed with the filing of patent application in India. In India, when we examine the provisions of Patents Act 1970 and the Patents Rule 2003, there are five kinds of applications under the Patents Act. One is called as ordinary application, which is directly filed to the patent office according to the provisions of Patents Act 1970. Second one is called as divisional application. Third one is called as conventional application. Next one is PCT application, and the last one is patent of addition. I will be introducing all these applications in brief, and thereafter I will proceed to the ordinary application, because as a rule, in most of the cases, in majority of the cases, ordinary applications are filed for grant of patent. Divisional application is an application when you file an application for grant of your patent over your invention, and based on your disclosure, it appears to the controller that your disclosure includes two different inventions. Then you will be asked to divide your application, and that process is known as divisional application, and the provision for divisional application is given under section 16. Let me clear it by giving an example. Suppose that you have invented a pen. Writing purpose के लिए आपने pen invent किया हुआ है. At the same time, you have also invented a pen holder. That is very good device to hold pen and will be able to be kept on your tables. In Inventing a pen is something different from inventing pen holder. There is no connectivity. And suppose that you file an application for grant of patent, and in that application you are claiming for patent protection over the pen as well as the patent holder. In that situation, you might be asked that grant of patent for pen is different from a grant of patent for patent holder, and you will be asked to divide your application and file divisional application for different applications, for different inventions. There are two inventions, two applications must be filed. That is called as divisional application, and in exceptional circumstances, that divisional application is allowed under the Patents Act 1970. Thereafter, conventional application. Convention application is basically in relation to any convention country. Convention country means any country which is also accepting any international document, following international document, and India is also following that same. Suppose that I'm asking about the Paris Convention of 1883, and Russia is also following that Paris Convention, is also party to the Paris Convention. In that situation, they constitute convention union, and in that situation, if any application is filed in Russia and the applicant is also having interest in filing application in India, that application is called a conventional application. Invention was particularly taken place in another jurisdiction, but by way of multilateral or bilateral agreements to which both the states are party, the application is also allowed in India. That is called as conventional application. Then thereafter, there is a Patent Cooperation Treaty National Phase application that is allowed under Indian Patents Act 1970. What happens under Patent Cooperation Treaty? Let's try to understand by an example. When you invent something that is very essential, that is a very good technology, and there is a huge demand of that technology. In that situation, definitely to get protection of patents in every jurisdiction, you must file application in all the jurisdictions. And there is a concept that is called as territorial jurisdiction of IPR. All the forms are territorial in nature. Patent which is granted in India is independent from the patent granted in Russia, granted in the United States of America, and all. If I invented something like that, I invented a vaccine which is very useful in treating COVID-19. I apply for grant of patent in India, but I look that there is a huge demand in other jurisdiction, and to get protection over my vaccine in other jurisdiction, I must also file application in other jurisdiction. In that situation, there is a treaty that is called as Patent Cooperation Treaty, which was concluded in 1970, and India became party to that treaty in 1998. That treaty facilitates international filing of patents. Remember one thing, there will be international filing of patents. There is no international grant of patents. When you file an application under this Patent Cooperation Treaty, you designate all the countries where you wish to get protection, and your application will be moved by the officials directly to those countries, and there is a saving of time, there is a saving of cost in grant of patents in multiple jurisdictions. If you wish to have protection in other jurisdiction, you must follow this route of the PCT application. That is very important, and that is allowed under section 138 clause 4 under Indian Patent Act. And thereafter, the last kinds of patent application is patent of addition. When a person files an application, for grant of patents, and it appears to the controller of patents that there is a requirement of any addition in the application, keeping in mind the specification, in that situation, the applicant may be asked to file a patent of addition, and section 54 is having the patent of addition, and the applicant will be filing a patent of addition. Patent of addition is treated as a new application, and all the process of this grant of patent is followed de novo. Out of these 5 kinds of patent application, what is important to us as a layman, as an ordinary man, is ordinary application. If I invent something in my individual capacity and I wish to have patent protection over my invention, I must follow that ordinary application, directly approach to the patent office, and in that situation, patent shall be granted according to the law. In my discussion, I will be focusing on the ordinary application only. Why? Because the patent procedure is a very lengthy discussion. It may take 5 to 6 hours to complete all the processes, all the kinds of applications. And I must focus in this ordinary application first. What is ordinary application and how it proceeds? But before that, I must tell you one thing, that is, in India, not in India only, in other jurisdictions too, the documents which are to be filed, that is patent application, is a very technical document, and what we call as it is a techno-legal document. If it is, applicant must be aware of the laws, and applicant must also be aware of the technology in which field he has invented something. If you are having sufficient basic knowledge of both the things, you will be able to file application by yourself. Otherwise, it is always recommended that the filing must be done by the patent agents. You must take help of patent agents who are qualified agent of under this Patents Act, and they are allowed to deal with the patent applications. They are called as patent agents. They will be your agents, and they will be filing your application on your behalf in your name, and they are aware of all the procedures of law, and they're also aware of that technology. What kind of technology you have invented, whether patent shall be granted or not, in what manner patent shall be granted or. In that particular situation, the recommendation is that don't try to waste time yourself. You may be able, exceptionally, you may be able to file your application by yourself, but as a general rule, must approach to the patent agent so that there is no any glitches in filing application, and your application is moving smoothly. So this is the particular. When we start filing of application, that is procedure of application in India, the first stage is filing of patent application. Filing is must, as I told you at the beginning. You have to file patent application, then only patent shall be granted. A patent application may be filed either alone or jointly by the persons. Now there is a controversial point in case of person, definition of person, as it includes natural as well as legal persons, legal entities. A firm, whether a firm may file application for grant of patents or not, or if I am financing a research, invention has been carried out by someone else, I only financed, whether I should be considered as an inventor or not, whether I should be allowed for grant of patents or not. In that situation, remember one thing. Under section 6, there are 3 kinds of individuals who are allowed to file patent applications. The first one is true and first inventor. Just try to understand who is a true and first inventor. The person who only financed a research, and any invention is a result of that research, definitely that financer is not true and first inventor. The financer is not allowed to file an application in the capacity of inventor. Why? Because it is not a true and first inventor. He has not invented the technology and he is not true inventor. The true inventor is the researcher. In that situation, the first question is, if any person is only financing any research and the research is carried out by some other person and the invention is reached by some other person, the person who is financing is not inventor. He shall not be treated as inventor. His name must not be mentioned in the application as inventor. Same thing in case of fur. In case of fur, initially in 1975, a question arose before Allahabad High Court, and the name of the question was Shining Industries versus Sri Krishna Industries. Shining Industries versus Sri Krishna Industries. The case was decided by Allahabad High Court in 1975, and in that case, the question was that whether firm may file an application for grant of patent as inventor or not. That was the question. Okay. The court concluded that no, firm cannot file application for grant of patent as inventor. Rather, in the second category, the firm may file an application for grant of patent as assignee of inventor. That is the second category. If a true and first inventor has assigned his right to someone else, that other person would be able to file application in the name of assignee. And in that situation, the agreement of assignment is must to be produced before the patent office as a proof, then only the application will be allowed. A very good example may be there. Suppose that any faculty member of this Jharkhand Rai University has invented, Mr. Sumit has invented a technology. Mr. Sumit has invented a technology in the capacity of employee. There's a contract of employment. If Mr. Sumit has invented that technology in the capacity of employee, he is the true and first inventor. But as for the contract of employment, terms and conditions, there may be terms and conditions that if any intellectual property is created by any employee of the university, university will hold all the intellectual property rights over those inventions and creations. In that situation, definitely, Sumit is a true and first inventor, but the university will be the owner of that particular IPR, and university will file application for grant of patent in the capacity of assignment. The employee has to assign that right as a requirement of terms and condition of employment to the university. Then only university will proceed for the filing of application. We all know that the Microsoft had invented many technologies. The Google has invented many technologies. We know the name of companies, Microsoft and the Google. Don't we know the name of scientists who actually invented in the capacity of true and first inventor of any technology? No. But fortunately, there's a requirement in the patent application, particularly in Form B in India, that when you file an application as an employer, in the capacity of assignee of invention for grant of patent, you have to disclose the name of true and first inventor. If you search simply on Google, any patent granted in the name of Microsoft, Google, anybody, you will find that the corporation files application for grant of patent as assignee, and the name of true and first inventor will be there. Scientist, Mr. A, Mr. B, Mr. C, unka naam wahan par hai. They must be given credit. You can't skip that part. That is the mandatory requirement under Form 2 under the Patents Act in India. And the third category is legal representatives. Legal representatives are also allowed to file application. I was in process of concluding my research, but unfortunately I died. Unfortunately, I died. I did not file application for grant of patent. My legal representative, my legal heirs are equally entitled to file application on my behalf, and they shall be granted patent. That is another kind of application. Applicants who may file application. Here, one technical question arises that when patent is granted in India, the patent is granted according to the provisions of Indian Patents Act 1970. And as we know that intellectual property is territorial in nature, patents shall be granted according to the law in India. Question arises whether foreigners should be given, should be allowed to file an application or not. Foreigners may also be allowed to file an application under Indian Patents Act 1970, provided there is a reciprocity between two nations. If I allow the citizen of Russia to file application in India, Russia must also allow to Indians to file application in that country. If there is a reciprocity, then the foreigners will be allowed to file an application. And there may arise a controversy. Suppose that I'm putting before you an example to understand this particular point. Suppose that China doesn't believe in any kind of reciprocity for grant of patents. China doesn't allow Indians to file application in its jurisdiction. But at the same time, China or any researcher from China wishes to have patent protection in India. If China don't believe in reciprocity, definitely the Chinese people will not be allowed to file application in India. In that situation, there may arise a controversial issue. Suppose that any Chinese researcher approaches to any Indian and he simply asks that file a patent application in your name and treat me as a joint applicant. I'm giving you that invention, file that application in your country, patent shall be granted in India. Indirectly, that researcher is trying to have patent protection in India. In that situation, the limitation is that if any invention is imported into India, then over that invention, patent shall not be granted according to the provision of Indian Patents Act 1970. Importation allowed for purpose of commercial utilization, but importation for grant of patent is prohibited. Otherwise, the controversy would be that countries which are not treating Indians as they are not giving opportunity to Indians to file application, they may have this way to file application in India. So importation and thereafter filing of application over that invention in India is not allowed. To proceed further, one very basic requirement of a patent application is that one application for one invention only. That is the concept of unity of invention. When you file an application, in a single application, only single invention should be the subject matter. Only single invention should be the subject matter of your claims. You can't file single application for multiple inventions. But when you file applications, different applications for different inventions for grant of patents, and all those inventions are connected with each other, that is called as unity of invention. Those inventions are based on the single inventive concept. In that situation, the patent office will ask you to file a single application for all your inventions, and that is based on the idea of unity of invention. What is that unity of invention? You may understand it better in by example. Suppose that I invented a pen and I proceed for grant of patent as a product, that pen, and also I apply for grant of patent over the process of that pen. The process of making something and the product, both are based on single invented concept. And if you wish to have patent protection over the process as well as product, in that situation, there will be the application of unity of invention idea, and you have to file single application for both. You are not allowed to file a single application for the process for the same thing and the application for the product of the same thing that is resulting of the same process. That unity of invention is there. That principle is justified in the name of to stop multiplicity of applications. When you file application, your application may accompany with the provisional or complete specifications. Specifications is basically a brief description of the invention. As I mentioned in the beginning that you have to disclose your invention to the patent office, then only patent shall be granted. When you disclose your invention, you have to disclose what you have invented and how your invention works. That is the requirement of specification. If you don't file a specification, your application may be simply rejected, or you may be asked to accompany your application with the specification. The specification is must. Drafting of a specification is very intellectual work. If you prepare a specification in such a way that ordinary man, skill in the art, is able to understand that invention and to come out with that invention, there will be chance of infringement of your invention, and there will be a chance of less commercialization of your invention. As before grant of patent, the devices will be available in the market. At the same time, you have to disclose your invention, the way that invention works, in such a way that the patent office is able to understand. Means you have to prepare your specification in such a way that the experts who are sitting in the patent office, they are able to understand your specification, but ordinary people are not able to understand that specification. And that's why your specification must be very concise, very precise, and must not be a detailed specification. One thing. Another thing is that under Indian Patents Act, the provisional application, provisional specification is allowed. Suppose that I'm about to finish my research. I may come to the conclusion in a few months, and I wish to apply right now application for grant of patent, fearing that someone else may file an application. As the date of filing is a very important date, and the who is inventor prima facie is determined on the basis of filing of application, who first files application. Keeping in mind, I provisionally file application with the provisional specification. In that situation, the requirement of the Patents Act is that in that situation, within 12 months, I have to file the complete specification. If I don't file the complete specification within 12 months from the date of filing, my application shall be treated as abandoned, and there will be no further proceeding in my application. Patent shall not be granted. A very good thing which started in 2007 was the online filing of application. The patent office promotes online filing, and since 2007 online filing is there in the patent office. Whole of the application may be filed online, and to encourage online filing, it provides a reduction of fee by 10%. If you are supposed to pay 10,000 rupees as a fee with your application for grant of patent in physical mode, you will be asked to pay only 9,000 if you're filing application in online mode. That is a very good initiative on the part of patent office, as in the online mode the services will be convenient, database will be available, documents will be easily available to the people, will be easily scrutinized, will be easily examined, and that's why that online filing, that is e-filing, is allowed. Jurisdiction is another issue that is not very important for us. For jurisdiction of the state of Bihar and Jharkhand, the Kolkata office is having jurisdiction. We may file application in Kolkata on the basis of our residence or place of business and all. If any micro, small, and medium enterprises are filing application for grant of patent, they have to accompany Form 28 with their application, and that Form 28 is basically asking for the details of that enterprises and all. That is very much also requirement in case of filing a patent. When patent is filed, your application is filed, the processing will start, numbering will be done, and there may be a secrecy direction. That is the important point. The provision is that if your invention is related to the defense and all, in that situation, the controller may direct that you must keep your invention secret. That is called as secrecy directions. And until that secrecy direction is not withdrawn by the controller of patent, you are not allowed to further proceed, and you will only be asked to proceed further for grant of patent once the secrecy direction is withdrawn. Secrecy direction is always issued by the controller of patent with the consultation of central government in the national interest, particularly the defense. If you are inventing something in the area of atomic energy, definitely holding processing of atomic energies to the individual is dangerous to the state. State must have check and balance. The state must have control over that. And in that situation, if you are inventing such kind of inventions, the secrecy direction shall be granted. And in that situation, Atomic Energy Act 1948, Section 20 particularly shall be applicable. That is one step, filing of application. You have to file application. The language is either English or Hindi, and if other language is used in situation, that the translation of a specification is to be produced within 6 months from the date of filing before the controller of patents. That is the requirement of filing of application. That is the first stage of filing. Next one is the examination of application. Once application is filed for grant of patent, now the second stage is the examination of your application. Examination of your application will be done either by the controller of patents or by the examiners appointed for that particular purpose. They are called as patent examiner. They are qualified persons to examine your patent application. What happens? To expedite your application, you may request after filing of your application for early examination. And for this particular purpose, under Section 11, Clause B, that request of examination may be filed within 48 months by the applicant or interested person. What happens? Just try to understand the logic behind that. When you file application, the grant of patent will be issued, and that grant, as we know, is a limited monopoly. Patent is usually granted for 20 years. International standard, 20 years. And that period of 20 years is counted from the date of filing of application. Suppose that I file application in 2021 until 2025. For next 5 years, my application is under process, and I have not still granted patent, but my limited monopoly start from the 21 itself. In that situation, many controversial circumstances may arise. There may be chance of infringement and all. Keeping in mind, the applicants are given this liberty to file a request for early examination of application. The examination application may also be filed interested person. There is a term interested person. Interested person is defined under section 2. Interested person is a person who is having research or business in the same area. I invented something in the area of any medicine for treating cancer. I don't request to the examination of patent for early examination of my application. In that situation, other research organizations, individuals who are involved in research over same kind of medicines for treating cancers may file an application for early examination of my application, because grant of patent to me will also hamper their interest also. If patent is granted to me, they will not be allowed to proceed further. They will not be granted patent for some kind of inventions. Means their interest will be dependent on your interest. If your interest is clarified, how far you have been granted patent, what is the scope of your claims, your specification, your inventions, then only they will proceed further. And if you don't file an application for examination, they may file. They have been given opportunity, and for this particular purpose, they may file Form 18, and the provision is given under Section 11, Clause B, Subclause E. A request of examination is must. If any applicant don't make a request of examination before patent office, his application, her applications shall be treated as withdrawn. Remember that. The request for examination is must. Examination will only start if you request before the controller of patents that the examination of my application should start. Now, when your application is examined, basically what are the contents which are examined? Examination of application by the patent examiner or the controller of examination, they examine three things. First, the formalities of application, the name of inventor, the name of assignee, their address, all details. At the same time, they also examine the patentability requirements, the criteria of patentability. As we know, the novelty, inventive step, industrial application, these are the requirements of patentability called as criteria of patentability. Your invention shall only be granted patent if it is new, having inventive step, that is also called as non-obvious, and the third one is industrial applicability. Otherwise, patent shall not be granted. That is called a substantive requirement. If there is a mistake in the formalities of applications, it may be easily corrected. But if your application, your invention doesn't qualify for this inventive step, is not having inventive step, or is not able to be industrially applicable, in that situation, your application may be cancelled. You may not be able to proceed further to contact patent. And some other formalities are also explained by patent office. That is, for example, unity of invention. When you file an application, whether you followed that idea of unity of invention or not. If you invented 4 inventions, and those 4 inventions are based on single inventive concept, in that situation, you must file single application rather than filing 4 different applications. That formality will also be examined. After examination, a report is prepared. That report is called as first examination report, and that report is a confidential report. First examination report is not a public document. That first examination report is communicated by the controller of patent to the patent applicant. And the controller communicate this first examination report to the applicant under section 24B subclause 3, and the provisions are that that communication may be online or offline, as the case may be. If online details are available, email ID is available, online communication would be there. If no email IDs of applicant is available, offline communication would be there. That report will be communicated. Any examination report, what we call as a first examination report, it may favor the applicant or it may adverse to the applicant, adverse to the interest of applicants. That report may be in favor of grant of patent or may be in adverse to the grant of patent. If the first examination report is in favor of grant of patent, there will be no penalty. Your application will proceed further to the next stage for the grant of patent. The problem arises if the first examination report is adverse. What does it mean? It means the first examiner report is not in favor of grant of patents to you based on some objections. The objections have been raised. If those objections are related to the formalities, you will be asked to amend those your applications. If those objections are related to the substantive formalities, in that situation, objections may be communicated to you, and if you satisfy those objections after giving you hearing, that the decision will be taken by the controller of patents whether the application will be allowed or not. If first examination report, FER, having some objections, simple, it says that my invention is not having inventive step. The objection has been communicated to me. In reply to that objection, I send my reply to, as a patent applicant, I send my reply to the controller of patent, and I explain that where is the inventive step in my invention and how it satisfies the requirements of grant of patent. If on the basis of that statement, the patent office is satisfied, the patent may be granted. But that is a very lengthy process. As we know that we believe in principle of natural justice, that the notice will be given to the patent applicant will be given chance of hearing, that is audi alteram partem, hearing proceeding will conclude, and thereafter decision will be taken. After completion of hearing, there may be two circumstances. Now the patent office is convinced that there is no objection as such and patent application should be allowed, or if after giving hearing to the applicant, the patent office is of opinion that the objections are still there and you are not able to satisfy those objections, and that's why you are not allowed to proceed further for the grant of patent. Those circumstances are present. What happens? An applicant, when he files an application for grant of patent under Patents Act 1970, at any stage before grant of patent, he is allowed to withdraw his application. Any time before grant of application with fee in case of objections are not met. If objections are not met and you are withdrawing your application, in that situation, a particular fee will be imposed. And recently in February 2021, a new draft of the rules was communicated by the patent office for the comment of public that is under consideration. And in that particular draft rule that will be amending the patent rules 2003, the different kinds of fees have been enhanced. I'm not sure what is the exact amount of fee in that situation. If you don't satisfy the objection and your application is withdrawn, in that situation also you have to pay a fee. That is a harsh situation for an applicant, a kind of discouraging factor. One thing, my application is not allowed, objections have been raised, I don't meet I did not make that objections. And at the same time, the patent office is imposing fee for withdrawal of my application. That is a kind of dual punishment for the same wrong. If my application, my invention doesn't qualify, it is having objections, simply my application should be withdrawn. I must not be asked for payment of fee. I'm not able to get the justification behind that. Does it mean the purpose behind imposition of fee by the controller of patent is that the applicant should try his level best to meet the objections rather than withdrawing the application? आप एप्लीकेशन विड्रॉ मत कीजिए, आप ऑब्जेक्शंस को सेटिस्फाई करने का प्रयास कीजिए. मे बी that may be one objection for filing more and more applications, as we are very far away from filing application. The data of filing of application is very poor. Very poor. Indians are very we are not very innovative. We are not having many researches, original researches, and you all might be knowing that in case of pharmaceuticals, more than 90%, 95% pharmaceutical industry is based on generic version. Definitely in generic version, you are not going to get any patent. For the grant of patent, to enhance this index of applications. Recently, since a long time, United States of America was at the top in filing patent application and grant. There was no competitor. But last year, immediately before the start of pandemic, China, Republic of China, superseded United States of America in filing and grant of patent. Now, most of the patents are filed and granted in Republic of China, People's Republic of China. China में grant हो रहा है, India में. ठीक है, India का ratio बहुत low है patent grant होने का. Maybe उसको encourage करने के लिए. Further, when application application filed and examination is done, the next step is that your application will be published. Your application will be published, and remember this publication is publication of your application before grant of patent. अभी आपको patent grant नहीं हुआ. You shall be granted patent after completion of the process at the end, but at the third stage after examination, your application shall be published under section 11 capital A. And what is the result of that publication? The result of that publication is that your patent application is no more a secret document. Before this publication, your patent application, even your patent application was a secret document. But after publication of your patent before grant, when it is published by the patent office, now it is no more a secret document, and it is also taken into consideration in determining the prior art of any invention. Now it is to be taken into consideration after publication for new invention, whether new invention is a new or not. If I file an application for grant of patent in June 2021, and someone is filing application for grant of patent over the same kind of invention in January 2022, application was the importance of application.
Sir, your voice is breaking.
Is it okay? Am I audible to all of you?
Yes, sir. Now it is okay.
Okay. So, publication of patent application is basically done after 18 months from the date of filing of application. And the rule 24 of the Patent Rule 2003 provides for publication of your patent application, but the statutory requirement is that your application shall be published only after 18 months. Remember one thing. What I observe while going through the procedure of grant of patent in India, at every stage, there is a kind of time-bound approach. After filing of application, you have to file request for examination in a particular time. Thereafter, publication will be done in a particular time. Thereafter, opposition will be raised in a particular time, grant in a particular time. The time-bound approach is there. And definitely it may be useful, it may be beneficial in granting more and more patents. If time-bound approach is there, the application shall not be pending for a long time. That is beneficial. And after publication, now it is part of prior art, and basic purpose of this publication is to give notice to the public. Why? Just remember one thing. If I have invented something, and whether my invention is new or not, having invented a step or not, whether it is able to be industrially applicable or not, all these questions are very technical, and you must be knowing, for example, novelty of my invention will be examined in the context of existing stock of knowledge of the world, whole world. Can you imagine that there is an official in the patent office who knows all the information about that technology? No. For this purpose, the purpose of this patent publication is that the public notice will be given. Public notice will be given that if any person is of opinion that the invention for which application is filed is not a new application, doesn't having this invented step, is not industry applicable, that person may raise objection against grant of patent. What we call as a citizen sue. Here I use the citizen objection. The patent office is proceeding further to grant patents to me, but whether patent should be granted to me or not will be determined by the public, and public has been given opportunity to raise objections against my grant. And if they raise a valid objection, definitely patent shall not be granted in my case. What happens in that situation? Basically, all those grounds have been given under section 25, over which objection may be raised by the public against the grant of patents to me. And remember one thing, there are two important dates. One is the date of filing, another is the date of publication. From date of filing, you shall be granted patent. But from the date of publication, after date of publication, from the date of publication, you will be allowed to file suit of infringement if there is infringement of your invention, even before grant of patent. Before grant of patent, my application has been published. After that publication, if there is infringement of my invention, I may file suit. Remember one thing, date of filing is important for calculating the monopoly, and date of publication is important from where the applicant is allowed to file suit against infringement of his invention. Okay, and for this particular purpose, section 11 is relevant, and request of early publication is always met under form 9. Form 9 is there, and by filing the form 9, request for early publication of application may be made. Early publication may be there. What will be the result of early publication? That application will become part of prior art early. Application will be open to the public scrutiny early, and objections may be raised in a particular point. The next point is pre-grant opposition, that is related to the publication. Pre-grant representation or opposition before controller by any person. Any person. Remember one thing, I have highlighted in any person may raise a representation, may raise objection before controller of patents against grant of patent to any applicant after publication of his application. There is still no grant of patent. We are still in the process of granting patent. This is called as a pre-grant opposition. Opposition before grant of patents. And there is a statutory provision that from the date of publication, next 6 months, patents are granted in any case. If my particular is published on July 2021, now for the next 6 months, there will be a kind of waiting period for my application. My application will not proceed further. What does it mean? It means for next 6 months, public is given opportunity to raise any objection if they are having against my invention. And if objection is raised, now the objection shall be accordingly. Grounds for free grant representation is given under section 25(1) from subsection A to section K. There's a long list of grounds. Someone is of opinion that my invention is not new. Someone is of opinion that I fraudulently acquired that invention. Someone is of opinion that my invention is not having inventor step. Someone is of opinion that I did not disclose any biological material which I used in my invention properly. These are the grounds on which the pre-grant oppositions may be raised by any person. Any means any. It is open. It is open. Delhi High Court, while discussing this ambit of this any person, who is any person, came to the conclusion that any person is not a person who is not having some basic knowledge of the subject. Any person here means the person who is having some understanding of the subject. If I oppose frivolously, without having sufficient knowledge about the application, without the invention, in such a circumstance, unnecessary there will be multiplicity of objections, there will be delay in application and all. And that's why Delhi High Court simply concluded in a case, that case, that any person means the person who is having some basic knowledge of such. When objection is raised, pre-grant representation is made, there will be two things. One, based on the objection of public any person, the application is refused. The controller of examination, controller of patent is of opinion that the application is not, the invention is not satisfying all the requirements of patentability, and that's why the application is refused. And if there's a requirement of some minor changes, the controller may also allow for amendments. In that situation, the only requirement is that to follow the principle of natural justice, notice should be given to the applicants and the person who is making objections. They both must be given chance of hearing, and after that, decision must be taken. A response to notice by applicant, controller refuses or requires amendments. After getting response from the applicant, controller either refuse or require amendments to the application as per the Rule 55, Clause 5 of this Rule 2003. And in that particular situation, what I repeatedly use that the request for hearing, controller may grant or reject the application. Request for hearing means the hearing must be given both the parties. Both the parties must be given chance of hearing. Then only decision must be taken. Principle of natural justice must be observed. That is pre-grant opposition. What happens after pre-grant opposition? That is the patent grant and publication. When application satisfies the requirements, there shall be grant of patents. Remember one thing. The grant of patent is the result of cumulative effect of satisfaction. If all the criteria have been satisfied, then only grant of patents will be there. Suppose that there are 5 requirements, all the 5 requirements must be satisfied, then the patent shall be granted. When patent is granted, the date of grant is the date of application. It is clearly mentioned in the section 45 clause 1 that the date of grant is the date of application. When you file application, the date is considered as the date of grant. Means when I file application in 2021 and patent is granted basically in 2025, in 2025 the patent shall be granted from back date, that is the date of 2021 when I filed application. Filing date is very crucial date in determining many things in the patents, and that's why the approach should be that as soon as you come to the conclusion of your invention, you must file your application as soon as possible. Don't make delay. After grant of patent, certificate shall be issued and the communicated that certificate shall be communicated to the applicant. That communication may be online, may be offline. Both the facilities are available. A granted patent shall be published in the official gazette and thereafter open for the public inspection under section 43 clause 2. Remember one thing: when a patent is granted by patents, that grant is not a proof that the invention has satisfied all the requirements of patentability and the patent application was according to the procedure of this Patents Act and rules accompanied with this. In that particular situation, any examination done by the patent examiner, controller of examination, doesn't warrant validity of patent. Patent has been granted to you, but if there is any discrepancy, in that situation, your patent may be revoked as well. A patent grant is not a conclusive proof that your invention has satisfied all the requirements of patentability. As I mentioned that the requirements of patentability is very technical. Sometimes it is very difficult to the patent office to examine the technicalities of the application, and in that situation, if prima facie it appears to the patent office that the patent is satisfying all the requirements of patentability, patent may be granted. But after that, if at any stage before the expiry of the monopoly, before the expiry of patents, that is 20 years, if it is found that the patent was granted wrongfully on the wrong grounds, it did not satisfy the requirements of patentability and all, in that situation, there may be revocation of your patent. Remember one thing: when patent is granted, doesn't mean as you have been granted an absolute patent. The limitations are there. The limitations are there that the revocation may be there of a patent. Examination doesn't warrant validity of the patent, section 13 clause 4, and the examiner try to understand this important reason why this provision has been incorporated under the Patents Act, that the controller or the examiners are not liable for examination or grant of patents. If there is any wrong in examination or grant of patents on the part of controller of examination or the examiner, patent examiner, they shall not be liable for any punishment. A saving clause is there in their interest. Why? It is presumed that they may not be aware of all the circumstances, all the facts. They may not be aware of all the developments of technology, inventions and all, and that's why that saving clause is required. Otherwise, if there is a provision that if the wrong patent has been granted by the controller of patent or the examination, patent examination has conducted a wrong examination and punishment provision is there, in that situation, they will be very cautious in examination and grant, and their cautiousness will lead to the delay. That is also good for the growth of industry, for the growth of science and technology in the country. And that's why this particular. But the remedy is that in that particular situation under section 64, which is not mentioned in this PPT, under section 64, there's a provision for revocation of patents. Patents may be revoked at any stage before grant of, before expiry of patent. There is another part that is obviously the last part of my discussion, that is post grant opposition. After grant of patent, there is a provision for post grant opposition. Means after grant event, people will be given chance to raise objections. But remember one thing, in pre-grant opposition, any person was given chance to raise representation objection. But in case of post-grant opposition, only person interested is given chance. Who is person interested? Person interested means any person or organization who is doing research or business in the same field. If I invented a vaccine, any other companies inventing the vaccine, doing business in the business vaccine and all, they may raise post-grant opposition. That is the definition of interested person given under section 2(1) subclause P of the Patents Act. The post-grant opposition after publication of patent grants and within 1 year by the interested person. Remember one thing. For the pre-grant opposition from the date of publication, basically there is a time limit of 6 months. Basically, if application is proceeding usually, 6 months time will be available to file a pre-grant opposition. But in case of post-grant opposition, statutorily there is a limit that the post-grant opposition must be raised within 1 year from the date of grant of. 1 साल के अंदर ही आपको पोस्ट ग्रांट ऑपोजिशन रेज करना, और 1 साल के बाद आफ्टर 1 year, not after 1 year, but from the date of grant of patent and before expiry of patent, at any time you may file application for revocation of patent. Means at any time objection may be raised against your inventions. In that situation, what should be the approach of an applicant? The applicant must be very meticulous in his research, must be very precise in application. All the requirements of application must be complied with. All the criteria of patently must be checked, so that there is no chance of any pre-grant opposition or post-grant opposition. Basically, what happens? If there will be pre-grant opposition or post-grant opposition, there will be start patent prosecution. Start patent prosecution, you have to spend around, you have to appoint some patent agent, you have to spend for the litigation and all. Unnecessary, there will be a cost effective to the grounds of post-grant opposition as same mentioned in 25(1) A to K. Means the grounds for opposition of patent, a post-grant opposition is same as for the pre-grant representation under section 25. There is no change in that. And if there is an opposition raised by any person interested against the grant of patent, the notice of opposition with the statement of interest, fact, and relief under Form 7, read with Rule 55A, shall be communicated to the patent holder, and the patent holder has to file his response that is called as notice of opposition, notify the patent holder, reply, patent holder has to file his reply, and if there is no contest, that objection has been raised and the patent holder doesn't contest that objection. Objection was raised against grant of patent to me. I was granted patent after 1 year, within 1 year, a patent objection post-grant opposition was raised. I did not reply to that. In that situation, the mandatory provision is that patent shall be deemed to be revoked. Revoke माना जाएगा अगर आप contest नहीं करते. At every stage, the applicant has to contest, and definitely for that contest, with the help of patent agent is must. You can't contest by yourself, and that's why it is suggested that you must be in touch with the patent agent from beginning for a smooth processing of your application and grant of your patent as soon as possible. When any patent is granted or any patent is revoked, as the case may be by the controller, party who is aggrieved by the decision of the controller may file application, that is application of appeal. And earlier the provision was that the appeal may be filed before the Intellectual Property Appellate Board, constituted under Section 83 of the Trademarks Act 1999. But recently, this year, 2021 itself, the Commercial Courts Act have been passed, and now the IPAB has been replaced by the Commercial Courts. That is the recent development, that the application of appeal before the commercial court should be filed against any order of the controller of patents. Controller of patents के against कोई appeal होगा तो वो commercial courts को file किया. And as per the Commercial Courts Act, commercial courts are basically a bench of the High Court, concerned High Court. And recently, in the last week, a first commercial court, first bench of the High Court was constituted by the Delhi High Court. That is the only example available today that the Delhi High Court has constituted a bench in the name of Commercial Court for the dealing with the issues of IP, where the appeals are filed against the order of controller of patent. In the meantime, another development has taken place in the light of judgment of alleged Shamnaz Bashir versus Union of India, 2019. In 2019, Delhi High Court ordered in Shamnaz Bashir versus Union of India, where the demand was that the filing of Form 27 by the patent applicant, patent holder regularly to ensure local working of patents. Basically, it was related to the compulsory license granted and the misuse of that provision of grant of patent in India to the pharmaceutical. Pharmaceuticals are applying for patent in India, and thereafter multinational corporations applying for patent in India, and thereafter they are only importing medicines from outside countries. They are not manufacturing those medicines in India. And in that situation, whether there is a local working of that patent or not, to ensure that compulsorily some changes have been made in the light of the judgment of Shamnaz Bashir, to whom we have lost last year one of the best mind in the field of IP, not only in India but at the global level, Shamnaz Bashir, who left us heavily last year, filed petition in the Delhi High Court, and that Delhi High Court order for change in the Form 27 of the Patents Act, and by this way it ensures regular filing of that working of patent. And that is a kind of challenge to multinational corporations which are only trying to import medicines from other countries and to commercialize it in India without manufacturing those medicines. That is over on my part. Some references have been given which I have used in preparing this PPTC. And now thank you very much to all of you for your patientful hearing, and if you are having any question, doubt, you are most welcome. I'm here to reply your questions. Thank you very much to all of you. Am I audible?
Hello.
Yes, Sumit sir, you are very much audible, sir.
Yes. Now
Yes,
it is
sir.
over on my part. If any question is there?
Yes. Thank you, sir, for innovative and this informative session. I am delighted to share with you, sir, that the chat box is full of compliment for you that shows that the participants really enjoyed your presentation. Sir, we have few questions. With permission, can I ask this question on behalf of participant?
Sure.
Sir, first question is, if a personal research means if any academician has done a personal research outside the work time is done by an existing employee of any firm, then does it fall under the employer's power to get the jurisdiction over its patent?
Okay. Actually, it depends on the IPR policy of the university. And as per the direction of the government, IPR policy is must for all the universities. What happens as an employee, as an assistant professor, if I'm inventing something and I'm using the resources of university, definitely the university must be considered as an assignee, and application for grant of patent must be filed jointly by the inventor and the university. But what happens? I'm doing some researches, which is basically in case of social sciences. I'm writing a book. I'm not using any resources of university. I'm writing a book on my own effort. In that situation, I may not be supposed to file application for grant of copyright with the university jointly. It depends on whether I'm using resources or not, and that will be determined on the basis of the IPR policy of the university. At the same time, the contract of employment with the university. How far university allows you to do researches independently, and how far you are doing researches with the help of the resources provided by the university. That is the question.
Okay, sir. Sir, the next question is, if I get my invention patent, am I free to build and sell my invention?
Definitely. If you invent a technology, you are free to commercialize it because you are having limited monopoly and all exclusive rights are given to you. But the problem is that you don't have industrial setup. You may not be able to commercially produce that product in the market, and in that situation, definitely what happens in normal cases, as in case of independent researcher, they assign their rights, that is basically transfer of their right. They enter into agreement with some industries and assign their rights to industries to manufacture that medicine. And that's why this innovative council of this Ministry of Education is asking for collaboration between university and industry. There may be creation of IPs in universities, but universities are not able to produce those products. उसके लिए आपको industry को approach करना पड़ेगा. If you are having resources, that is good. If you don't having resources, you may enter into an agreement of license or assignment, as the case may be, for its commercialization. Because mere invention, mere having invention is not sufficient. Commercialization of that invention is must, so that the benefit of your invention is to the society, and also you are having some commercial benefits.
Okay, sir. Sir, the next
Okay,
one
sir.
is, what are the modes of filing a patent application in foreign countries?
Foreign countries, when you file application in foreign countries, if that particular country is part of the Paris Convention, or that particular country is also following the Patent Cooperation Treaty, in that situation you will file application under Patent Cooperation Treaty, and your application will also be facilitated by the Patent Office, that is called as the national phase of Patent Cooperation Treaty, Patent Cooperation Treaty filing. Both options are available to you, and if countries are not party to the Paris Convention or the Patent Cooperation Treaty, but they are having bilateral understanding, you may file application independently in that country for grant of patents.
Okay, sir. Sir, one very interesting question is there.
Sure, sir.
Yes, sir. One participant has asked that, what are the reasons that India's patent filing application position is low?
among top 50 countries. China
Yes.
is on the top.
Yes, yes, definitely, you are right. There are multiple reasons. One reason is that the procedure is very lengthy. People are not aware of this lengthy procedure, or you may say that people are not aware of IP protection. Don't think that there is no creativity, there is no innovation in India. There is a huge amount of innovation and creativity is going on, but people are not taking care of the IP protection. One thing. Another thing is that the filing is very costly. The filing is very complicated. As I mentioned, that the help of patent agent is must. But what happens in the recent times, the Indian Patent Office is making it convenient to file application online by yourself, and the tendency is that individuals are filing application with himself, and definitely in future we will be having some high filing of application. But I believe that the reason is the ignorance. People are not sure whether if I spend 20,000 rupees in filing a patent application, whether I will be able to get benefit of 20,000 by commercializing my invention. That is the reason. Or you may say that not very path-breaking inventions are taking place. ये भी एक reason हो सकता है. But remember one thing. If you examine the database of Google, you examine the database of Microsoft, you examine the database of the multinational pharmaceutical corporations, everywhere you will find most of the researchers are from India. They are doing the researches, they are inventing things, they are getting patent protection in other jurisdictions, but not in India. That is the complexity of law, maybe ignorance. एक joint वो रहेगा आपका.
Yes. Sir, the last question is,
Okay, sir.
to be a patent agent, is it necessary to have a basic legal knowledge?
No, there is no necessity to have legal knowledge, but you must have the understanding of the patents and the law so that you may be able to file application. What happens? Remember one thing. If I file my application myself, in that situation, I must have knowledge of law, procedure, and all. But if I approach to the patent agent, I only disclose my invention to the patent agent, and I leave everything to the patent agent, and patent agent will proceed with the application. Whether you must have knowledge or not, it depends whether you are taking help of patent agent or not. If you are able to have, if you are having sufficient knowledge of law and you find yourself convenient to file your application by yourself, you may file. There is no limitation. It depends on you. And I believe that having knowledge is not bad. Having knowledge is not bad. If you are able to have knowledge of patents, that's good.
Okay, sir. Thank you, sir, very much for answering all the questions clearly and patiently. Now I would like to summarize. First, starting from the filing of application, we have discussed the principle to be followed: first to file or first to invent. Then we have discussed different stages of ordinary patent application, e-filing services, steps in examination of application, how to request the examination, what is the process of withdrawal of application, publication of patent application, discussed various pre-grant oppositions, patent grant and publication, and lastly we have discussed what is post-grant opposition. Now, sir, on the behalf of Jharkhand University and the entire team, let me call it as a JRU fraternity, and on my own behalf, extend a very hearty vote of thanks to Dr. Digvijay Kumar Singh, sir, for your gracious presence and sharing your important knowledge with us. It was indeed a privilege to have an expert like you in our FDP. Thank you, sir.
Thank you very much, sir. Thank you.
Participants are requested to submit the assessment of this session and feedback at the end of the session.
And the next session will be chaired by Dr. S.C. Roy sir on the topic copyright in digital era, and that will commence from 2 p.m. sharp. Participant, please join on the time. Thank you, sir.
Thank you very much. Thank you very much to all of you.